Okay, I'm teaching chapter 20 about employment law. So we'll start with employment at will.
Okay.
Employment, I'm teaching Heather. Employment at will is the doctrine that allows employees to quit at any time or employers to terminate employees at any time for any reason.
Okay.
And this is central to the United States, but isn't always the case in other countries. But there are exceptions that judges have made to the doctrine at will, such as contract tort and public policy theories. So first there's contract theory. Um, so contract theory is when employers make a contract with employees that strengthens this and that they're only to be let go at goodwill, such as budget cuts or employees' performance. And courts will see if employees employers let employees let go in good cause. And if they were let go in good cause, courts will first look at HR and see if they were let go, and usually they are put through like a disciplinary process, and this process shows if they were let go at good cause. Courts will also look at if they how much time it took for them to be let go. Someone let go after 2 months is usually let go in good cause, but if it's been 15 years, then it may not be. Courts also look at the quality of work period. Workers who receive a lot of praise and achievements can use that for to help them in their good cause. Tort theory. So this is Tort theory is something an employee can use against the employer if the employer let them go in an embarrassing way. Say they told everyone that they're going to fire them over email. They could sue an intentional infliction of emotional distress and get some money. And another example would be fraud, where an employer moves that employee to a state knowing that that job would be eliminated in 2 months. So those are both examples of tort theory. Next one is public policy. This is the most common, and this is where people are fired against the state's statutory policy laws, such as firing someone based on sexual orientation or gender identity. If an employee is fired for this policy, the employee could bring a lawsuit against the employer for discrimination or just any discrimination. Other exceptions at goodwill cause employment includes so here's some other reasons. The If the employee was refusing to commit illegal activity, the employee wasn't allowed to exercise their legal rights or performing an important public obligation, jury duty, or whistleblowing. So all those three, if they weren't allowed to do those and were fired, then they could bring that up in court and say that they were fired for wrongdoing. Whistleblowing. So whistleblowing is telling the government that their work is unsafe or illegal activities to the public. And if their work fires them for that, then that would be wrong and would be um at not at will, and they could sue for that. Wrongful discharge. So this is when an employee is wrongfully fired against their contract or against the law. So pretty much everything we just talked about, and can bring a wrongful discharge lawsuit against the employer. Child labor. So everyone knows about child labor. This is So the Fair Labor Standards Act, FLSA, made wage hour requirements for all employees in the US and the basis for federal minimum wage laws. The FLSA also prohibits obsessive child labors. It So it does allow children under 14 to do hazardous work. So children under 14 can work delivering paper, agriculture work, and entertainment, and working for their parents. Children 14 to 15 are allowed to work, but non-hazardous work, and children 16 to 18 can work longer hours. And then after 18, it doesn't matter. These rules don't apply. Overtime. So overtime, the FSLA applies to workers who work more than 40 hours a week, and it is 1.5 their normal pay for every hour that's over their 40 hours of regular. These does not apply to special workers who are called exempt workers, like executives and administrators. And more employers try to classify their workers as independent because they don't want to pay overtime. Family and medical leave. This is also this is called the FMLA, and this allows workers to take time off for medical reasons. And a lot of employers are pay for time off for medical reasons, but it's not, the law doesn't make them. This, uh, but the law requires them to make them, so basically it requires them to make employers allow them to take time off for medical reasons, but it doesn't require them to pay them for it. But so if you have more than 50 workers, you have to let them take time off. Some reasons an employee can take time off are to care for a baby child within a year of birth, to care for a new adopted foster child, to care for the employee's immediate family with serious health conditions. If the employee has serious health conditions and is unable to perform the essential functions of the job. While the employee is on leave, they cannot be fired or have their medical coverage be taken away.
What?
When they return, their job must be returned and just have it the same way as when they left and have the same pay benefits. And if the employer violates this law, they must pay for any pay that was lost or any damages. Here's some other workers' protections. Workers' compensation. This is if a worker is injured at work, the employee can get financial benefits for those injuries. And if they make a claim, they can't make a lawsuit against the company later. And the injury must happen at work and because of the work. Workers' compensation includes lost pay, medical costs, and rehabilitation. Unemployment insurance, if if you got let go by the company or employer, an employee can apply for state unemployed benefits, and the benefits are based on past earnings for a limited time. They can't get this unemployment if they're let go for egregious behavior such as theft, frequently failing to come to work, etc. They must also be looking for a job continuously. Social Security disability. Those are for people who are unable to work because of their disability. They must show that they can't work, and it is easier for people over 50 to qualify for disability. the Affordable Care Act. This is the ACA or Obamacare. Medium or large company must offer medical insurance to employees or face penalties. This is privacy. Workplace privacy is allowing employers to supervise their workers while also protecting employees' privacy. And that's everything. Okay.